I wanted to kind of give folks just an overview of what's been happening and what that looks like for your patients, and what you as medical providers can do to advocate for your patients, both at a sort of very local level or personal level to a more wider audience. Um, so just a quick disclaimer, right? Anytime you have a lawyer, you have a disclaimer. So this presentation is for informational purposes only. It doesn't establish policy or any legal rights, doesn't constitute legal advice. So I think it's really important to get a sense, to take a step back and understand what this, compare this moment to where we were. So just to give you a sense, in 2016 was the very first time that transgender issues became a national political issue in the 2016 election. And so then by 2018, we see sort of a slight increase, right? This number of just over 40 bills nationally. That's in all 50 states, right? It was up from, just over 20 the years before that. So not a significant shift. But then COVID, in the lead up to COVID, there was this rapid increase, and at least at first, the COVID pandemic blunted some of the ability of state lawmakers to consider these bills. But this legislative session, we've seen over 500 bills on anti-LGBT issues. And these bills initially started with just bills about specifically healthcare and accessing healthcare for transgender young people. But now it's expanded to cover so many different topics. So for example, in the context of education, you have bills that exclude teaching about LGBT people in curriculum, exclude school libraries from carrying resources about LGBT people, or that include LGBT characters in nonfiction novels. Then you also have the medical treatment bans, which is probably the ones that you're most familiar with, which started out as sort of bans against really providers providing advice about and prescribing care. And it started out with just being a sort of a violation, a professional violation, so that the state medical board could discipline a medical provider who prescribed medical treatments for the purposes of a gender transition. And then it really ratcheted up, and quite quickly in Alabama was the first state to pass a bill that criminalized providers. So it wasn't just a professional penalty, it was actually a felony that came with 10 years in prison if convicted. We also have states restricting the ability for transgender people to correct identity documents so that it correctly reflects their name and correct gender marker. There are many attempts to limit access to public accommodations, specifically bathrooms, right? That we saw that kind of run through the media back in 2014 and earlier, and it's come back. We've also seen state funding measures. The state of Oklahoma told the Oklahoma University Health System that we'll give you $40 million, but you have to promise in exchange, to build this new facility, but in exchange, you can no longer provide transition-related care for transgender young people. And lastly, we're seeing lots of states, or an increasing number of states, try and designate or define a parent's consent to medical treatment for gender dysphoria as abuse or neglect, and warranting the removal of children from their home and placement either with in the foster care system or with kin. And what has been really amazing, of those over 500 bills that got introduced this legislative session, although it's, in a raw number, still quite large, only 86 passed, right? So the vast majority did not make it through the legislative process. And there were a number, even of those 86, where the governors did not sign those bills. In Utah, for example, the governor of Utah, they sent him a bill that would ban transgender girls from participating in girls' sports throughout Utah. And he actually had a meeting with transgender kids as he was considering this bill. And he vetoed it. And he talked about how the reason he's vetoing is he met these kids and he can't do that to them. He can't harm them in that way. And also the reality was that of the 75,000 young women who are participating in high school sports in Utah, 4 were transgender. And so the idea that this was actually a problem that required any kind of solution was absurd. The response was not only came from transgender young people and organizations that work with the transgender community, but also the medical community, and that was huge. And we saw that in statements from the organizations like the AMA, the AAP, PES, and other major organizations that are involved in pediatric care. And that also then kind of leads into the next point, which there were lawsuits filed about many of these bills. And courts across the country have enjoined these laws from ever going into effect. So in Alabama, for example, a federal judge in Alabama entered an order prohibiting the state of Alabama from ever enforcing that law, at least on a preliminary basis until the case goes to trial, which is currently scheduled for April of next year, right? So thankfully, young people in Alabama and providers in Alabama can continue providing the standard of care treatment for gender dysphoria without worrying about criminal penalties. But in that order, the judge repeatedly talked about how there are over 22 major medical associations in the United States that treat this as the standard of care for gender dysphoria. And how can a state criminalize what is the standard of care? I will say other states have sort of tried to go even lower with, for example, Florida has tried to change the Board of Medicine rules to essentially say that in Florida, providing what is known to be the standard of care treatment is not the standard of care. And even a federal court also prevented those rules from being put into effect. What has also been interesting to see is on the flip side, we've seen states like California enact laws to strengthen their legal protections for transgender young people, both as a sort of political statement of support, but also recognizing that even in states like California, there is more room to do better. But we can't ignore the severe impacts that all this has had on transgender young people and their health, right? We've seen an increase in suicidality, an increase in negative mental health outcomes, anxiety, depression, feelings of hopelessness. There's also an increasing avoidance of care, right? And we know this happens when people experience discrimination, they just don't seek care, right? And this is not providers discriminating against their patients. This is the state discriminating against transgender young people, and they're saying, we're just gonna avoid care. This is having an impact on their education as well, lowered sense of safety and belonging, which also is linked to lower GPAs, lower mental health, and all sort of negative outcomes. And also we're seeing rapid increases in discrimination and mistreatment, not only by the community, but also by family members. And then as a result, there are many families who are relocating to states with stronger protections for transgender youth, which is good sort of on a global sense, in the sense that they can access medical care and things like that, but they are taking those young people out of their support systems, right? What we have seen, at least in my experience at NCLR, is that although states are passing these really harmful bills, these young people are living in communities that are extremely supportive. Right? They have friends, they have family, they have people, they have a support network. And you know, many families feel like they don't have an option anymore, and so they move, but they're removing these young people from those support networks. So I want to sort of take a step back and sort of, how does all that fit into here? So the California Civil Rights Department, its mission is to protect the people of California from unlawful discrimination in a wide range of areas, including employment, housing, public accommodations, and anything that is state funded, as well as we have some authority around protecting people from hate violence and human trafficking. And so what does that look like? We investigate complaints and cases of systemic discrimination. CRD has mediation services. There's a whole division dedicated to dispute resolution. We do enforce California state laws by filing lawsuits in state court and federal court. And we also put together regulations that further flesh out what is the meaning of California's strong anti-discrimination laws. So for example, California was one of the first states to propose a regulation that talked about and implement a regulation that talked about how misgendering a transgender person is a form of discrimination. We also collect data, particularly on pay and demographics for large employers. And then we do outreach like this to help educate folks about us as a resource and also about the strong anti-discrimination laws that we have here in California. So I'm just going to quickly give you a list of the laws that we cover. Some of them, as you'll see, are very much employment focused, so not necessarily are going to be for the patients that you see, although to the extent you're seeing adolescents, they do apply for jobs. And so these are things that could come up in their lives. And so the FEHA, or the Fair Employment and Housing Act, is a very broad anti-discrimination law that prohibits discrimination on a wide range of bases, including gender identity and sexual orientation, but it also includes race, sex, pregnancy status, and many others. It's quite a long list. There's also the Equal Pay Act, which prohibits pay discrimination on the basis of sex and race. I will say the Unruh Civil Rights Act is probably the one that's going to be the most relevant, because this is an anti-discrimination law that covers businesses and public accommodations, right? So if your patients are experiencing discrimination in restaurants, stores, hotels, those kinds of things, the Unruh Act is what would cover them. And then we also have the Ralph Civil Rights Act, which prohibits or protects people against hate violence and threats of violence based on a variety of protected characteristics, including gender identity, as well as race and sex and many others. So although in some states there is an argument to be made that transgender young people or transgender people in general would also be covered under state laws that protect people on the basis of disability, because state law is so strong, that is not as necessary here. But there is also the Disabled Persons Act, and then the human trafficking laws that we enforce. And then finally, the recipients of state funding. So any entity that receives state funding, public or private, falls within the scope of our authority to investigate and litigate. So how does all this affect your work, right? So first, and I think really critically, especially when we're talking in Pride Month, is ensuring that your practice is equipped to care for transgender patients, right? Ensuring that providers and staff are aware of the best practices and feel comfortable and confident implementing those practices is one of the things that we often see is people know what the best practices are, but are concerned, oh, am I gonna get it, am I gonna get it right? I don't wanna, there's this fear of like, if I don't do it 100% right, maybe I shouldn't do it at all. And so it's really not just sort of making sure they know what the best practices are, but they feel like they can actually do it in their day-to-day work. And then ensuring that policies and procedures reflect the institution's commitment to equal access and care for transgender patients. So for example, one of the cases I worked on while at the National Center for Lesbian Rights was against a hospital in Southern California that admitted a transgender patient on an involuntary psychiatric hold due to suicidal ideation. And while he was on in the care of the hospital, there were several nurses and other staff that made comments to him about, saying things like, "Oh, sorry for that I keep misgendering you, but you look like such a pretty girl." And needless to say, his mental health continued to deteriorate while in care, to the point that he actually had to be released. That the psychiatrist felt it was better for his mental health to be released 30 hours early than to remain for the full 72 hours of that hold. Then the other thing that I think is important for your work is that assuring that patients and parents that they are safe and have legal protections, right? That even though your patients live in California or are in California at the time that they're seeking your care, there's still that anxiety of they see everything that's happening around them, right? And so being able to assure them that if you're experiencing discrimination, you're protected, right? I know that you're seeing these things in states all around you, and maybe even in your communities, right? That you are safe here, right? That there are laws that protect you here, and sort of helping build their not only their knowledge but also hopefully their resilience. And then educating patients about available resources. It's really critical that if your patients are experiencing discrimination, that they do file these complaints, right? This helps agencies like CRD really understand what is happening throughout the state and really track that information and really understand how we can either change the way we're doing our training and outreach to ensure that we are serving the needs of all Californians. So I did want to kind of quickly go over the complaint process so that folks know what that looks like. The complaint process is super easy. It's accessible. You don't need a lawyer to do it, right? You can either go online to calcivilrightsca.gov. That's the agency's website. You can download the intake form, and you can either, if you want to, I don't know who has faxes anymore, but if you wanted to, you could fax it in. Scanning, mailing. You could also come to one of our offices. We have offices in Elk Grove. Oakland is probably the closest geographically here, but there's also Los Angeles, Fresno, Bakersfield. Any of these offices you can come in and complete a form, or if you wanted to, also you can call the department and they can do an intake over the phone. And so once a complaint is filed, then we begin our process. We'll interview the person who filed the complaint, and if it's something that we have jurisdiction over, we'll help sort of prepare the formal complaint and send it to the complaining party for their signature, and that really starts the process. I will note too that filing a complaint with CRD doesn't affect a person's right if they wanted to file a lawsuit to do that. But then we begin our investigation. And our investigation looks like you would expect, right? We interview witnesses. We might go out to the site if that's an important part of understanding the facts and what happened. We would get documents and other information from the alleged party that perpetrated the discrimination. And we would ultimately, we do that as a neutral third party, so we don't represent the complainant or the respondent. We are just trying to assess what happened. Throughout this process, the parties have access to our mediators if they wanted to do a dispute resolution, right? And essentially mediate the dispute and settle it amongst themselves. If it doesn't ultimately, if they attempt mediation, there's no resolution, we'll ultimately issue a finding of cause or no cause, depending on what the investigation finds. And then we may decide, depending on the particular facts of the case, we may decide to litigate it and file a complaint in court on this issue. But we are doing that on behalf of the state, right? So that looks very different than an individual who's saying, I'm the plaintiff, right? They are involved in the process and are certainly an important part of the process. But we are coming in as a state and saying, based on our investigation, discrimination occurred, and we want to ensure that the state's anti-discrimination laws are properly enforced. And so we are coming in as the state and making sure that that this discrimination is cured. Before I move on, so that ends the sort of the CRD portion of this presentation. I want to see if there are any questions about that aspect of what I talked about. Okay, all right. So now I'm going to take off my CRD hat and now talk as just a lawyer. And so I want to talk about other legal issues and protections that are available and out there, and things to think about as you work with transgender young people. As Tandy knows, one of the things that I did a lot of while at NCLR is talk about families in conflict. And what we have seen, when people asked, for example, when I was at NCLR about, have you seen the Trump effect in any way? What was the effect of the Trump's winning the 2016 election? It was this. It was that parents who had concerns about their child transitioning felt emboldened to rely on pseudoscience or, really ratchet up the level of disagreement to really block their children from accessing medical treatment. This is an issue that we saw parents separate over, or if it was parents who had already separated, it became yet another thing that they fought about, right? Which obviously, again, has a really significant effect on a young person's mental health. And I think what I would encourage you all to do, especially in this moment, given all the sort of the hyper focus on this, and what I hopefully what Tandy has come away with all the times we've talked about this, is that communication and keeping a patient-centered approach is critical, right? Because one thing that will happen is an unsupportive parent will always try and paint those that are disagreeing with them as not really following their sort of professional ethics and doing what you as professionals do, but following some kind of agenda, right? That is overriding what you do as providers every day, and in following how you provide care. And so it is really critical to encourage communication and understanding between the parents. One of the things that often gets lost is that unsupportive parents, with very rare exceptions, are acting out of love, right? That they often do this because they have their own anxieties and fears about what it's going to mean for their child to transition. And what has unfortunately happened with this proliferation of misinformation about the standard of care is that then they feel like, oh, my fears and anxieties are validated by, what I'm reading on these various blogs and websites that are telling me, look, all these people regret their transition, that this is, medical castration and all these very scary terms, right? Right, my child's 7 years old, but they're talking about performing surgery, right? And that's not the standard of care, right? But they believe it, and they really care about their child. And I think that's really important to sort of bring that back into the room. And one of the things that I'll say as a shorthand, I will say supportive and unsupportive parents. But one of the things that I've learned from the research on family acceptance is, in fact, we should talk about parents who engage in supportive behaviors and parents who engage in unsupportive behaviors. And no parent is entirely one or entirely the other, right? And that does two things. One, it really helps drill down on what are the behaviors that are helping or hurting your child. And that is one of the wonderful things about the research that was done by Caitlin Ryan at the Family Acceptance Project in San Francisco State University, is she actually was able to identify specific behaviors and their effects on young people, right? So if a parent started using a child's correct name and pronouns, it would have, you know, this amount of positive effect on a child's mental health and well-being, right? And actually what she found, just as an aside, was that the most negative thing a parent could do is practice conversion therapy. It was even more negative than a provider practicing conversion therapy. And, what that research overall found is that, unsurprisingly, that the level of family acceptance or rejection was the single most determinative factor of a child's short and long-term health and well-being, right? So the higher levels of family rejection were correlated with higher levels of substance misuse, suicidal ideation, long-term mental health long-term mental health issues, and a number of negative outcomes. Whereas on the flip side, higher levels of family acceptance were correlated with positive outcomes, that these young people felt like they had the ability to deal with the daily discrimination. It really buoyed their self-esteem and their ability to function well. And so I think that's why I wanted to sort of lay that out. And again, there are parents who do some supportive behaviors and some unsupportive behaviors. The benefit of focusing on the behaviors, though, is that it really lowers the bar. It allows you as a provider to say, look, I'm not saying, that tomorrow you're just going to accept your kid 100%, although I think that's the right thing to do for your child's health and well-being. But why don't we start with this small thing, right? Why don't we say allowing your child to have that toy that they really want, that's sort of very gender affirming for them, or using their name or this nickname, it's a gender neutral nickname, right? So to start to get them to do little things that will help their child improve their mental health, but also communicate to their child that their parent loves and supports them, even if they can't do it in the way that their child may need fully. I think it's also really critical is to provide information and resources to parents to help them understand their child's needs, right? And one of the things that happens, although there is, an increasing number of really great resources written by parents, books and other things, and written by providers, it gets drowned out by all the misinformation. And the misinformation, unfortunately, feeds into people's existing anxieties. And so it feels, easier to access and more believable than what is actual good information. And all the purpose of this, right, is to ideally help the unsupportive parent become supportive, right? Because if you're talking about, let's say you're talking about a young person who is we're just talking about social transition. We're not even at puberty. We're not talking about any sort of traditional medical interventions, right? If you can get the parents to start agreeing about care for gender dysphoria at that age, it's going to prevent them from fighting about everything else all along the way, right? If they continue to fight, they're going to fight about everything. They're going to fight about social transition. They're going to fight about blockers, about hormones, about everything that they can fight about, they will fight about. And so the more you can do things to help bring them on board and help them understand the critical nature of this care, even if it's not sort of, again, traditional medical care like blockers or hormones, but just with social transition, that is really important. And then encourage engagement in care. Just as an example, one of the cases that came up while I was at NCLR was a case where the parents were separated, had been for a long period of time. One lived in Northern California, one lived in Southern California. The mother was the primary caretaker, but because of the mother's medical issues, the father did have substantial caretaking responsibilities for long periods of time. And so it wasn't a situation where one parent was the primary custodial parent and the other parent was just kind of cut out of the picture. And this case started with um, the parents agreeing, okay, our child is experiencing issues around their gender. Let's take them to a gender therapist. And at each point of each step, it was really the providers that were in control of what happens next with the care. And each provider was communicating with both parents equally, right? Ensuring that even if dad was in Los Angeles, that he could either come to in person, this was pre-COVID, in person to the sessions, or have access to the therapist to talk about, what their observations have been in sessions, et cetera. And the same thing happened when it was time for this young person to meet with a pediatric endocrinologist at the beginning of puberty, right? They scheduled the appointment at a time that he could come up if he was able to, but if he wasn't able to, that the pediatric endocrinologist would make sure to make themselves available to talk to him, answer any questions. And the process went slowly like that, certainly slower than this young person would have wanted, but the end result was really amazing. It got to the point where the pediatric endocrinologist said, look, your child needs to start estrogen. That is the next step. The father really struggled with it, and ultimately came to the conclusion that I can't in good conscience, as the father, consent to this. But if mom is willing to do it, I will allow her to consent to this one decision. Right. And so the child was ultimately able to get estrogen. Sorry, that was blockers. Fast forward a few years later, it was time for estrogen. And the process started over again, right? Now the medical providers is recommending that our child start estrogen. Let's start, appointments and all that stuff. And his response actually surprised all of us. His response was, he was upset that it wasn't his daughter calling to ask him about estrogen. It was, all these people it was the lawyers, it was, other people. And he really saw him stepping aside and consenting, or allowing mom to consent to blockers, as extending an olive branch. He recognized that he had caused damage to his relationship with his child and wanted to repair that relationship. And so it's really important, to the extent that you can do that, is, encourage engagement and care, and then offer clear recommendations, right? One of the things that, obviously you want to make sure that parents and the young people that you're treating can make informed decisions and provide informed consent. So you want to give them all the information that is necessary to do that. But then ultimately providing a clear recommendation of what you think is the best approach from a medical perspective, and talking about what are the potential consequences of not following that recommended path, are going to be really critical. Kind of going to the sort of bringing the other parent on board, is trying to identify areas of agreement between the parents, right? Because if you can get those little areas of agreement, that can really help. Just like the story I'd mentioned, there have been many other cases where we've seen unsupportive parents withhold consent for blockers, right? But then in talking with them, you can get them to agree to, well, let's do blockers. Maybe we don't do the implant. Maybe we just do the 6-month Lupron injection, right? So we're not committing to 2 years or a year. We're committing to 6 months, and let's see how it goes, right? And often what these parents will see is that their child blossoms, right? And that their relationship with their child improves dramatically, right? And that is feedback that helps them then really understand the significance of this care, and really understand why it's so critical for their child. And we often see, again, that those families don't come back, right? It doesn't become an ongoing fight. They might fight about other things. In fact, they probably do. But this is not one thing that they fight about, right? If that's unsuccessful, I think it's really important that you as providers be a resource to the folks that are then going to be involved in this family's life. It's going to be lawyers, it's going to be custody evaluators, it's going to be guardian ad litem, or lawyers appointed to represent the interest of kids, of the kids in the dispute. They're, those people are seeing all the same information that everyone else is, and they're affected by it too. And there is, I can't tell you how many assessments I've seen that are just unbelievable. We worked on a child and abuse and neglect case in Michigan, and the child at the time was 3, almost 4 years old, and they brought the child into a therapist's office, and the child had the therapist had set aside 3 piles of toys, and this was his way of determining what gender this child was. And one of the toys the child played with was a microscope, which according to this therapist was a boy's toy. And so then said that this child is a boy, right? I mean, but this is not how this care is done, right? And so being able to educate providers in these spaces about what is appropriate, right? And what would you expect to see, and the other thing that happens too, and some of you may have seen this, particularly in high conflict situations where a transgender young person is affirmed in one home and not in the other, and so they switch genders, right, between the homes. And that is very confusing for people, because then it sort of feeds this idea of like, oh, something's going wrong in that house, right? If they're choosing a gender that's not consistent with their sex assigned at birth, there must be something wrong there, right? And so as providers, you can talk about why a young person would act in that way, and why that's not sort of an indication that something's wrong in the supportive parent's home, that in fact is quite the opposite. That is the unsupportive parent's home that is not affirming and causing this child anxiety. And then lastly, serving as an expert witness, right? Courts, two things. One, judges are human beings, and they're, again, seeing all the same information everyone else is. But in order to rule in favor of your patient, they need that information. They need to know why this is the standard of care. They need their own anxieties about, many people will feel like, okay, if we're starting blockers, or we're allowing this child to socially transition, does that mean that they're gonna, that they're on, this is sort of a self-fulfilling prophecy. They can't sort of later say, oh, you know what, that actually just wasn't right for me. And what does that look like, right, in terms of their mental health and their physical functioning, right? Those are really important questions that you as medical providers can answer. Related to this, and kind of going back to the first part of the presentation, one of the things that California did, Governor Newsom signed a bill, SB 107, that was really intended to make California a place where families who are living in states that are passing these bans on healthcare and otherwise, implementing these anti-trans bills, that they can come to California, and California will be a safe haven. And what that means for you as medical providers, for example, is if you do get a family from one of these states, right, and are providing care to them here, if an agency in the state where they came from then seeks your medical records, you are actually prohibited from complying with those subpoenas, right? The idea is to safeguard those medical records, right? To prevent, for example, although the Alabama law is not in effect, assuming it was, a family in Alabama coming to California, obtaining care that is entirely legal and appropriate in California, and then returning to Alabama, and then authorities in Alabama trying to charge someone with a crime, right? Because the law in Alabama not only applied to providers, it also applied to parents. And so medical providers are prohibited from releasing medical information. This also applies to insurance companies as well. The other thing that it does is that it confirms that state courts in California can exercise jurisdiction over family disputes, even if they started outside the state of California. And where that becomes relevant is, let's say a family, there is an ongoing custody dispute. Sorry to pick on Alabama, but just the one we've been talking about in Alabama, and the supportive parent moves with the child to California, right? That allows the California courts to at least assess whether or not they should take emergency jurisdiction, right? There's been a lot of misinformation about this. It's a sort of complicated thing in general, and so others have seized on that to sort of spread misinformation that it's this sort of automatic right, and all these parents are going to be coming to California and forcing, you know, um, you know, trying to game the system essentially. And that's not what's going to happen. What happens is it just creates an opportunity for a parent to demonstrate that the California courts should take jurisdiction and could potentially enter orders regarding custody. This law also prohibits enforcement of child abuse and neglect laws from other states. In California, you might get, sometimes they could issue warrants and other things like that from other states. And so it prohibits compliance with those attempts. So in my last few minutes, I just want to kind of outline the sort of other areas of advocacy for doctors here. And really the possibilities are endless. It's really about sort of where you want to plug in and where you feel comfortable, where you feel like you have the time and energy to plug in. Because the reality is that your expertise and trusted voice are critical, right? Doctors are among the most trusted messengers, and among doctors, pediatricians are the most trusted, right? So you are in a particularly unique situation to be sort of a voice for transgender young people and your patients in particular. And so these are just some suggestions. This is not an exhaustive list at all. But one of the things that we're also starting to see in some of these laws and also just local school boards is that there's this sort of concern about transgender young people coming out at school, and that school, mental health personnel or teachers are withholding that information from parents, and that's this really terrible thing. And doing advocacy with local school boards so they don't adopt policies that require teachers, guidance counselors, and others to automatically out their transgender students to their parents, and why that would be harmful. Assisting generally with public education efforts, right? That is on the sort of very local level, talking to the parents in your networks, right? Not the parents of the patients that you see, but just the people because there's lots of misinformation out there. And what we know is that in order to reverse some of that misinformation, it requires longer conversations that you can't have in a 30-second ad, right? These are sort of sustained relationships. And so having those, these are people people you can talk to, submitting op-eds to your local paper. Those are also really important. Submitting, pieces into the journals that are going to be read by peers who may not have a whole lot of interaction with transgender patients. Any kind of aspect of public education that you can assist with is really important. I think continuing to advocate for your professional organizations to join efforts to oppose anti-transgender legislation. Tandy can talk about what PES has done in terms of putting out statements, joining amicus briefs to sort of indicate to courts, this is what the medical establishment understands to be the standard of care. Those are extremely helpful. And the broader that support goes, the better. And you may think to yourselves, oh, well, I'm a pediatric neurologist. What does that have to do with it? Well, that is just as important, right? Yes, it is great to have organizations like PES who are often charged with the bread and butter transgender care. But it is just as important for all the other subspecialties of pediatricians to stand up and say, look, this is a standard of care. If I'm treating a transgender young person, in my specialty, I'm also making sure that they're obtaining this really important care, because it could affect their other health conditions. And then lastly, serving as an expert witness. It is such a critical need. There are unfortunately many providers who espouse anti-transgender views that will misrepresent the research that's out there in ways that seem defensible when you first read it, but are truly indefensible when you actually engage with the underlying studies. And judges really need someone to be able to come in and say, look, I've read this research, I've treated transgender patients, and that's not what this person is saying is not accurate. And in fact, what we see is that the medical providers who are often brought in as experts in support of anti-trans legislation are medical providers who have little to no experience actually treating transgender patients. For whatever reason, maybe that's probably for the better. But if you have that experience and can bring that to bear, that is really critical for judges to hear. And I think that is it. Thank you all so much. I'm looking forward to your questions. And if you do have questions about CRD, that's where to contact us.
Are there questions that we want to start in the room? And then I have some questions that have come in through the chat as well. Yes.
Recently been hearing is putting pressure on, on some of the professional societies not to hold conferences and other sort of money generating activities in states that are having are not supporting gender affirming care. And I was just wondering your perspective on, is that an effective approach? Is that something that we should be pushing for as members of these societies?
Yeah, so I think that's a great question. The state of California does not allow state employees to travel to any states that have anti-transgender legislation on the books. Is it something that is going to get a governor to say, oh, well, maybe I shouldn't do this terrible thing that I'm about to do? Maybe not. But it is going to send a message to patients and to the community that their providers are standing with them. And I think that is a really important message in this particular time when, really what this legislation does in sort of a practical sense is it doesn't give transgender young people adults to talk to, right? It is separating them from their teachers, their counselors, their doctors. And so really taking the stand and saying, no, we're here for you. We are a resource for you, I think is really important. And that's one way of doing it.
You actually have a long list of questions, and I have to say it's pretty impressive, but there are about 135 people who joined virtually as well. So first of all, can you comment on the legal landscape surrounding placing transgender youth in single-sex medical settings? For instance, shared hospital rooms, residential mental programs that might be different from what was assigned at birth.
I can speak for sort of under California law, and I would certainly say, again, in my non-CRD hat, that federal law requires the same, is that you can't discriminate on the basis of gender identity, right? Full stop. And what that means for sex-separated facilities is that transgender young people should be treated consistent with their gender identity for all purposes, right? And what that means in terms of as providers, one of the things that I've seen as a best practice is just letting everyone know, right? If you're gonna, for example, in a inpatient psychiatric facility, right? If you're gonna have a roommate, tell everyone, just know you might be housed with a transgender person, right? Let them sort of say, I'm not going to be comfortable with that. And then you can make an accommodation for that person, right? It's not excluding the transgender person, but it is managing the needs of the patients that you have. And so it certainly it's both sort of a legal requirement and then also just some public education and sort of figuring out the processes for that. But that is the standard, is to ensure that transgender people are accessing those facilities consistent with their gender identity.
The next topic is about release of medical records. And so what if you as an MD do not release the medical record? Is that you or is that Stanford? And could they theoretically have a warrant for your arrest for disobeying the court in the anti-trans state? Or is that protected under SB 107?
So I am really hesitant to give legal advice, especially when you have your general counsel, who's really the one tasked with doing that. You know, if you are refusing to provide medical records consistent with the state law, I would presume it'd be very hard to go any further than that, right? It's not that you are just saying, I just don't want to give them to you. You're saying I can't, right? I'm actually prohibited by law from complying with this request. And so, you know, that said, to the extent you have concerns, obviously you'd want to, before refusing to comply with a subpoena or request like that, you'd want to check in with general counsel at Stanford and making sure that you are doing everything, you know, in accordance with their recommendations.
I do have to say we have, I know they're on, and we do have an amazing risk management who I think, you know, when we call, they already know us. I think by now they're like, oh, is it Tandy or Jonathan? Like, which one of us is calling? And they're very responsive. Also related to medical records, what happens if a parent has come to California to seek care, but, you know, a lot of our medical records are shared with an EMR and maybe another parent has access who might not be as affirming. What is available to parents or guardians through that medical record via the Cures Act? So, you know, a parent going back to Alabama comes to Stanford for care, could that other parent then get the information from the chart and use that as legal action?
So I'd actually want to take a step back from that. If you have any indication that the parents are in disagreement, that is just a very different situation. You're not going to want to, you're going to want to see any kind of custody agreements or orders that sort of delineate who has medical decision-making authority, right? Because it may be a situation where both parents have joint decision-making authority, and so you can't prescribe care without the consent of both. I will say, even in situations where you have a parent that has sole legal and physical custody, it is still really critical to proceed with extreme caution, because until that child is 18, the courts can get involved. And so you want that parent to be prepared for and understand what the consequences may be, and have legal advice, and also for yourself, what that looks like. I mean, I think, you know, if the parent has sole medical decision-making authority, then, you know, their consent alone is sufficient. But again, something you probably want to clear with general counsel. But in terms of taking a step back and looking at the patient, right? It may be that this parent has the authority to consent, but what is that going to do to this young person's family life, right? Is it going to destabilize it in ways that are maybe more significant? And so just taking that into account when treating those patients.
I know there's a few other questions that are all related to medical records, but just for the sake of time, another topic I just want to make sure. How do you feel about, or what do you know about the federal legislations that's looking into banning federal dollars to institutions that provide gender affirming care, for instance, CHGME, you know, institutions that train pediatricians?
Yeah, so I think, you know, at this point, those federal bills will be introduced again, because this is also just part of a larger political movement, you know, or political strategy. given the current state of our federal government, it's not going to go anywhere, right? Even if it somehow passes the House and Senate, President Biden is not going to sign it. You know, and in fact, the discussions at least have largely been with regards to kind of those restrictions, is actually removing restrictions. There are also restrictions on providing money for abortion care and other things. So I think we're hopefully going to go in the other direction.
That's great. For the sake of time, I just want to really thank you for coming today and to make sure that you don't leave Stanford here without one of our annual Pride shirts. So thank you so much for always leading with love.
Thank you.
And we'll be around. Thank you all so much.
The preceding program is copyrighted by the Board of Trustees of the Leland Stanford Junior University. Please visit us at med.stanford.edu.